Okay, we should be set up and good to go now. Again, my name is Paul Thaler. I'm the Director of External Affairs with the National LGBT Bar Association. Thank you so much for calling in today. I'm just going to give you a brief topic introduction to this and introduce our speakers, and then hand it over to our moderator for this call-in. The topic introduction, as all of you know, the LGBT Bar is pleased to host this call-in with this topic, co-sponsored by the Hispanic National Bar Association and the National Asian Pacific American Bar Association. So on Wednesday, November 9th, many of us woke up to a new reality. In light of the nationalist and hateful rhetoric of this campaign season, it is safe to say that immigrants now face new dangers and an increased risk of deportation. In a number of countries around the world, individuals are killed for their real or perceived sexual orientation and gender identity or expression. Whether or not LGBT immigrants are allowed to stay in this country can become a very real life or death situation. The United States currently hosts more than 11 million undocumented workers who provide an irreplaceable workforce. Leading experts in the field have joined us today and will discuss the current state on the immigration and deportation crisis in the United States. So to start with our speaker introduction, very first is Scott Titshaw, Associate Dean of Academic Affairs and Associate Professor at Mercer University School of Law. Scott has taught immigration practice and has written extensively on immigration law and legal issues concerning sexual minorities. Prior to entering academia, he practiced immigration law for 12 years. Next is Elaine, Cintron, Associate Attorney at Lichter Immigration. Elaine is a lawyer with extraordinary experiences working to protect LGBT immigrants. As an associate at her firm, she has participated in numerous. She is an associate at her firm, and she has participated in. She's an associate at her firm, and she has participated in numerous community outreach events in hopes of educating our most vulnerable populations and helping to end the unauthorized practice of law. She is a 2016 recipient of American Immigration Lawyers Association's National Joseph Minsky Young Lawyer Award for her contributions to the field of immigration and nationality law. And lastly, Noemi Masliah, born in Havana, Cuba, has practiced immigration law since 1980 and is now a recognized expert in the field. Her practice areas include family-based immigration matters and routine and complex employment immigration cases for permanent and non-permanent work visas. She advises corporate clients on compliance with immigration law and regulations. She is a co-founder of Immigration Equality. So now that I have set all this up, Scott, I want to pass it to you to start this conversation.
Great. Thanks, Paul. And I'm also really happy to be here with Elaine and Noemi, who've been in the trenches dealing with some of these issues. We'll talk about that later in our call at some of the detention facilities in the southern United States. Also, I'm really happy that this call is being co-sponsored by three different organizations three very different organizations. I think coalition building is going to be a really important thing in working together over the next couple of years, so I was really happy to hear that. But I wanted to start our discussion with something that I hope won't take too long, and that is I've had several contacts here, several friends of mine who are same-sex couples where one person is from the United States, one person is from another country, and the foreign national hasn't yet obtained U.S. citizenship. And some of these people are concerned. They're worried that maybe their marriage won't be recognized for immigration purposes, that they might have trouble obtaining immigration benefits for their children. Should they be worried? What do you think, Noemi?
I'll go out on a limb and say I don't think they should be worried. I think, the basis of immigration benefits for same-sex couples and their children are, come from two landmark decisions recently issued by the Supreme Court, Windsor being the first where the federal benefits were bestowed on same-sex married couples, and the second being Obergefell, which said that same-sex couples have the right to get married under the due process law of the Constitution. Those cases are very recent. I don't think the Supreme Court likes to overturn itself, certainly not that quickly. So I believe that on the basis of those two cases, same-sex couples are safe.
And Elaine, do you have anything to add? Do you think that they, even if in general those rights are safe, do you think there might be more concern after January than there has been over the past couple of years?
Yeah, I agree with Noemi. I think you've got landmark decisions in place that I think are going to continue to be in place. What my concern would be, and as a matter of anything in immigration law, you'll see there's a huge element of discretion, and where I would be fearful in just preparing clients for their interviews at the local field office, and they're going to be asked about questions of their marriage and whether it's a bona fide marriage in order to approve. I would be a little bit concerned in prepping the clients and making sure, just in case there's some officer that decides to change the way they're supposed to be adjudicating these cases based on the new administration and whoever ends up heading Homeland Security. I would just do a little extra layer of prep. There are training manuals that officers are supposed to be following. My concern would just be in the climate after Trump takes office to see how that's going to be continue to be implemented in each local field office.
If I can say something, I mean, and if I in the consular process context, since under the Kerry being Secretary of State, and he with the help of the American Immigration Lawyers Association, certain procedures were implemented that protect foreign nationals in same-sex marriages that are consular processing. We've asked that in countries where those posts are where the foreign national could be endangered, if anybody knows that he's not only gay but in a marriage case, that the interviews be held in private rooms and not over the counter. The same for fiancé cases. And another Secretary of State could say, disregard those instructions, and they have to have the same interviews as everybody else in non-confidential settings, and that could be very, very scary. So there's that piece that we have to be very well know that could change.
I think you both make really good points that these unwritten procedures or even written procedures might change somewhat. It might disadvantage some people, and in particular that just the culture of a government agency can change, and that in areas like this where there's a lot of discretion exercised, that can pose problems if there are any issues at all. So I think those are good things to note, but hopefully people will be reassured that we don't think the law itself and the recognition of same-sex couples and of their relationship to each other and their children if they're married is likely to change for immigration purposes anytime soon. So I think that's a good takeaway. Probably the best news we may have to talk about all day. How about you two are both full-time immigration attorneys. You've both done this for some time. Noemi has done it for even longer than I did when I was in practice. How has the election impacted your practice? What have y'all seen change?
Well, for one, I have to say that I feel, and I told you this yesterday, that I feel that I've become a therapist, because even though they may not be, in many cases, anything to worry about, the fear factor has increased for so many people. Just dealing with clients every day and assuring them that they'll be okay, or yes, maybe we have to consider filing your case sooner rather than later in the event things change. For example, in employment-based cases, having nothing to do with LGBT issues, Trump and his folks want to be more restrictive, even as to legal immigration. So, many clients want to start their cases sooner rather than later. Same-sex marriage, for example, with a foreign national may become a Muslim country, they want to start their cases, even though they may not have thought about immigrating in the near future. They just want to get that under their belt. A lot of people that want to naturalize, even though they may lose the citizenship of their home country, given that they're well settled here and they don't plan to return, they're just biting the bullet and say, let me naturalize, just in the event changes to my situation. That's what I'm saying.
Elaine, have you been seeing? Yeah.
Yeah, from I do a lot of what we would just call defensive work. So folks that are already in removal proceedings, which is, essentially they're going to court in front of an immigration judge and trying to persuade the judge that they're eligible for relief to stay in this country rather than being removed. And I think from our perspective, what we're seeing a lot is panic of what's going to happen in my court date. Is the release that I'm seeking no longer going to exist by the time I get to my court, my last hearing? A lot of panic, and I think overall the panic is trickling into the community. And in dealing with local community organizations, you're seeing a lot of rumors. Also, something to be mindful of is notario fraud and people beginning to make promises that they can go ahead and get things filed. They're going to make sure they can stay in this country. So be mindful of that as well, that there's always some folks that are looking to take advantage of others. But I agree with Noemi. It's a lot of being a therapist, having folks that have won their asylum case that are now permanent residents, wondering if their asylum's going to be taken away. Dealing a lot with people who are in the state of panic, limbo, and unfortunately,
and the dreamers, we all have, we've all handled the dreamers. They are shaking in their boots because they think it'll be rescinded on January 21st.
And Noemi, can you explain to people who you mean? Who are the dreamers, and what's going to be rescinded in January?
Right. Dreamers is a deferred action for childhood arrivals, and these are kids who were brought here to this country by their parents when they were very young. And through executive action, President Obama granted them work permissions and the ability to stay here. It wasn't a status. It was just a recognition that they were here and they should get work permission so that they could get Social Security numbers and go to school and work legally. And that has been so beneficial to, I think, over 800,000 kids. So, but that's an executive order, and an executive order is not a regulation. It's not the law. And it was implemented by Obama because he saw the necessity. And Trump has said that, as soon as he can, that's one of the first things he'll do is rescind that order. And, Janet, I don't know if everybody read it, but Janet Napolitano, who was head of Homeland Security under Obama, yesterday she had a beautiful op-ed in the New York Times begging that it not be rescinded because it's been so beneficial, not only to the children, but to the employers that have them, who value them, to the universities and the schools who have them there as outstanding students for the most part. So, this is a very, very frightening situation for so many.
And I think part of that fear, as I recall, is that a lot of the people, as part of this program, have had to file documentation with the federal government indicating they are here, they're out of status, even though they arrived as children. They've had to indicate if they've had any minor arrests or imprisonment, any sort of criminal record at all. They've had to indicate their addresses, a lot of information that would potentially make it easier to find them. Is that a concern that you're hearing from people who come into your offices?
Sure.
Yes.
Sure.
I think especially for kids who it's kind of like one of those things where you have to advise everybody about their risks. And it's a difficult position to be in as an attorney because we're in this, nobody knows what this lovely president-elect is going to do. So it's hard to advise of risks that are kind of up in the air. He says one thing and then does another the next day. But that is a level of concern is, okay, if I'm going to file this initial application and I'm putting myself out there, that will be in the system, right? But then there's the other side of the kids that are scared to even file renewals, and that's the heartbreaker. Their stuff is already in the system, their information's there, and they're reluctant to even file. And I think that's the sad, heartbreaking. There's the logistics, right? Okay, so the information's in the system, but then also how their lives, their everyday lives, are completely transformed each day. Wondering, is it okay? I get to go to work today, or I get to go to school today. Is that going to change in the new year? and being able to kind of calm those folks down. One of the things that I speak to DACA kids about, especially considering their age, I mean, if they're under 18, do they have what we would call lawful presence? And then also discussing their records. Most of these kids that I've worked with don't have criminal convictions. And because it's DACA, right, they're having a severe criminal conviction or anything that would give them a sentence greater than a year would put them in a position where they wouldn't be eligible to begin with. And so kind of calming those fears down in the rhetoric that we're hearing about deporting criminals versus you're a DACA kid, right? And this is an executive action. We understand it's in the system. Your information's in the system, but also your record. Let's think about your record. That provides some solace, but at the same time, there is a lot of uncertainty.
And I've also had, Scott, I've also had kids who feel responsible that if it's rescinded, not only will they have to leave the country, but they will lead to their parents because their parents live with them, and they will get removed. And the parents have been working here so hard, sending money to El Salvador, sending money to Mexico, supporting those families. It's horrific.
No, that's a very good point, and I know there's a tremendous amount of fear out there. I guess just to sprinkle a little bit of positivity here. I know Noemi mentioned initially she called the children with or the young adults now with DACA or Deferred Action for Childhood Arrival. She called them dreamers. Because before there was DACA, there was a DREAM Act, which Congress perennially introduced, and which was perennially was not enacted. Senator Graham apparently has said within the last day or so that he would introduce a new, some sort of new DREAM Act. Out of concern for the DACA kids. So I guess at least there's some outside possibility of a legislative fix on the horizon again, without an executive who will help out. But obviously the executive is part of the legislative process as well. So I guess that's all something we can look for. How about other people? There are purportedly around 11 million undocumented persons living in our communities in the United States. The Obama administration set forth certain enforcement priorities. Elaine, could you tell us a little bit about what those are and how that might change under a new administration?
Sure. So one of the things that you can advise folks about are the current enforcement priorities that were issued on November 20th, 2014, which most people recall November 20th, 2014 as the day that DAPA was announced, which was the program similar to DACA, but for the parents of U.S. citizens. And what happened on November 20th, 2014 is that along with the DAPA announcement, we had priorities that were released, which basically says, look, we don't have resources to deport 11 million people from the United States, so we're going to focus on three priorities, so folks that fall into these three groups. And the first priority is what you would think it would be, the main priority, which would be, folks who are deemed to be threats to our national security or public safety, terrorist associations, things like that. Also clumped with priority one are folks that are entering the United States. So recent entrants, ICE is calling priorities. And so you'll see that, and we'll get to this topic later, you'll see how that falls into place when you look at places like Dilley, Texas, where the Family Detention Center is located, because those folks, those recent entrants, are deemed priorities for removal. And so that's why they're processed quickly. Your second enforcement priority are folks with criminal history, so convictions. And this seems to jive with what Trump is saying, right? Let's get rid of folks with criminal records. What's interesting about that is that that's already a priority. That's priority two, with folks that have convictions for things, for example, domestic violence convictions, DWIs, which is probably the most common where I see it in my practice, are DWIs and DUIs, enforcement priority number 2. And then the third enforcement priority are folks that have a removal order after January 1st, 2014. And so one of the talking points when you're trying to deal with all the fear that's now just rampant is to say right now these are the enforcement priorities. So we're gonna focus on that. You're okay for the time being if you don't fall into them. The problem is, and what's scary, is that this can change under the new administration, and it can change quickly. And that in itself is what terrifies folks. And also just looking at it from the government's perspective, if these enforcement priorities change, we already have a severe backlog in our immigration courts. The folks are waiting for years to go through their hearings. Our court was backed up till 2019, and we're just now getting recalendared for 2017. But that's our jurisdiction. So across the board, across the country, the courts continue to be backed up. So if these enforcement priorities change, that means more people are going to be kicked into proceedings, and they're going to make more backlogs in our immigration court system.
No, that's a good point.
Yeah, and and it has to be set. All these policies, these instructions are set out via policy memoranda. They're not laws, and so they can be revoked. They could be just turned around, and new restrictionist ones may replace them. That's the uncertainty of all this.
No, that's right. And even if if you use a category and you say someone who has been arrested of a crime, or criminal aliens, if that's the term you want to use, that can mean so many different things, and it's meant fairly serious crimes and something beyond an arrest, I think, generally in the past few years. And I assume even if a new administration stuck to what they called criminal aliens, it might be a broader category than that category is perceived as right now. So I think there could be changes without even changing the phrasing of what the president-elect has said so far. How about, we've heard a lot about Muslim registration, about rounding people up, and about the some sort of registration system. People have cited the Korematsu case and what happened during World War II. And I guess just starting with registration itself, is that something that we can expect to see? And if so, how do you think it might look?
Well, that we have the NSEERS, the National Security Entry Exit Registration System, or it was called Special Registration, which was implemented under W. Bush as part of the war on terrorism in the aftermath of 9/11, and it was initiated in September 2002, and it was suspended in April 2011. It's still there. It was just suspended by Obama in April 2011. And that the portion of the program relevant for this discussion was the requirement that non-citizens, meaning tourists, students, work visa holders, people who are here temporarily, males under the age of 16 had to register, had to go to the INS office and register. They were from 25 countries, all of them in Asia or Africa, and 24 of them were predominantly Muslim, North Korea being the sole exception. From that program, more than 13,000 men were deported as a result of it. The purpose of the program was to see what terrorists could be found, and not one terrorist-related conviction came out of that effort. Trump has said that he could use the same program, expand it. He doesn't want a profile, so he says it could extend beyond Muslim men and make it even probably include women as well. And, given that the program was driven not only by the Attorney General at the time, Ashcroft, by a staffer at the DOJ at the time, whose name is Chris Kobach, who's now Trump's one of his closest advisors, and who knows what role he'll have in the administration. it could be very easily implemented again. The organizations have asked Obama to abolish it before he leaves office. He has less than 2 months to do so. We can only pray he does.
Yeah, I agree. I lived through that era as well as an immigration attorney at the time, and NCERS was not very productive as far as what it was intended to do, and it certainly created a lot of problems for a lot of law-abiding immigrants in the United States.
And for purposes of this discussion, Scott, who knows how many gay men were in that? Among the 13,000, who know how many trans folks were in that, that group, so that who were removed without knowing.
We had people who were seeking asylum in the United States from one of the countries, and because they were born in one of those countries, and as I recall, it dealt with birth, not just citizenship.
Right.
They still had to register and re-register and do everything you did with NCERS. So they were sort of double stigmatized in those situations. Speaking of sort of terrorism and the specter of terrorism as something that is being used to restrict immigration and to create different immigration enforcement priorities, one of the things that came up during the election was this idea that terrorists are sneaking into the U.S. as refugees. Do y'all think that's likely?
Laney?
No.
I don't. No.
The answer is no. I do feel that's a fear tactic. I mean, to get refugee status, it's a long process, and people are waiting outside the U.S. I think what I saw the most was this kind of folks confusing the difference between asylum seekers and refugee status. I mean, when one's seeking asylum, they do have to meet the definition of a refugee, but it's a completely different process. And so this idea of having folks that are presenting themselves at the border, being terrorists and somehow coming in as a refugee, I don't even know logistically where that came from. But essentially, my answer is no. I do not see terrorists going through the refugee process, which already has extensive vetting. I just don't see that being a real issue. I think a lot of that was just talking points to generate fear to the population.
Certainly not the easiest way to get into the United States generally, right?
Right. And those refugee camps are so inhospitable that I don't see, an alleged terrorist wanting to spend up to 2 or 3 years in one of those. So.
Right. Yeah, it seems like if you were trying to come up with a way to infiltrate the United States with terrorists, then that would not be the easiest way. But I will point out that that is a very old argument that was made during World War II when people were trying to escape Europe. In the era that gave birth to the whole refugee and asylum regime, and I won't get into that history, but it's a pretty profound one. How about, Elaine, you mentioned this difference between refugee and asylum status, and I suspect some of the people listening out there might not understand what that difference is, and it's more a procedural one as opposed to what you're proving about yourself, right?
Right. So when you're seeking asylum, you're in the U.S. rather than being outside seeking refugee status. So there's this difference between meeting the definition of a refugee, having this fear to be in your home country, and facing persecution. With asylum, you meet the definition of a refugee and demonstrate your persecution on protected grounds, on account of a protected ground. And essentially that's being done while you're in the United States versus seeking refugee status while you're outside the U.S.
Before we continue with this, I actually just got a note a minute ago from Paul that if anyone does have questions, you can email the questions to him at Paul, P-A-U-L, at lgbtbar, all written together, .org. That's Paul at lgbtbar.org. So if anyone out there has questions, feel free to email those to Paul, and he'll try to get those to us. But back to discussing, after that commercial interruption, back to discussing asylum and refugee status. I know that one thing, and I know Noemi's worked with this a lot over the years, including before this was recognized by Janet Reno, but one way of showing that you qualify for asylum or refugee status is to show your fear of persecution, your well-founded fear of future persecution, or that you have previously been persecuted due to your status as lesbian, gay, bisexual, transgender. Is that something that might be in danger at present, and how might that be affected?
I mean, it depends on how pessimistic you want to be. If you want to be very, very pessimistic, yeah, you could say it's in danger. It's a case that Janet Reno certified, the matter of Toboso, that said that being gay made you a part of a member of a social group that could be recognized.
Yeah.
I'm sorry?
I said particular social group.
A particular social group, right. Another case could come up the ranks where it's denied, and that attorney general certifies that case, yeah, they're not members of a particular social group. But I think as immigration lawyers, we know that being this particular social group is so ingrained. Other countries have held the same. It's part of the refugee body of law. So I think we would certainly be outliers were we to hold otherwise going forward.
Yeah, I think that makes sense.
I agree.
Elaine, you were going to say?
Yeah, I agree. I think, for a particular social group, there's, especially with the case law that already exists for folks that are LGBT, that we've already have case law that holds that it's innate, right? It's something that it's an immutable characteristic. I don't see that changing. And in terms of the particularity requirement and social distinction, that's clear. My only concern, and I don't want to be the Debbie Downer in the group, but also is just seeing how case law is changing for trans folks. We've had, luckily, and Immigration Equality had a part in that in the Ninth Circuit case for trans folks and showing past persecution based on their gender identity. But that's an area where it is changing because the government has been arguing that there's gay marriage in, the AFA in Mexico, so everything's great. So you are seeing a little bit of that kind of back and forth. But in terms of the particular social group itself, I don't see that being impacted. But what concerns me is the interpretation of whether there is past persecution and then unable and unwilling to protect you, the government component, the country conditions, how those arguments might change in the future for LGBT asylum seekers.
And I would add that I've seen over the years a real distinction based on what country one is from and what the United States relationship with that country is, and to the extent that we're, potentially best friends with Russia in the future, for instance, it might be that might disadvantage someone who's seeking refuge in the United States because they're being persecuted as a gay person in Russia, for instance. So that the foreign policy component of this is a little bit something I would be wary of as well.
Yep, I have several Russian gay cases in the pipeline, and they're very worried for that very same reason.
Yeah, and I think that is something to at least be concerned about. How about someone who is seeking asylum in the U.S. based on their persecution, and their real claim is based on their HIV status. That's their the primary reason why they're being persecuted. Is that something that is recognized, and is that something that might change in any way?
Again, I think, that it is available, and folks with HIV, AIDS have obtained asylum on that basis. Whether I can't see that changing unless the country conditions in all over the world change. That medication is available for everybody. Nobody's persecuted or stigmatized because they have HIV. I don't see that happening.
I agree.
So really our issue, I guess our issue in a lot of these cases is that a lot of what we rely on in the area of immigration and citizenship, well, immigration law at least, is memoranda, policy, norms, and things that aren't statutory in nature. So theoretically they could change, but y'all are not afraid they'll change overnight. And certainly the things that are embedded in a statute, I think, are less likely to change quickly. But even some of these other things where there's a lot of precedent on which they're based and maybe international agreement on which they're based, that's not something you foresee as changing soon.
No. But no, not at all. Those things not. But for example, I thought of the provisional waiver. The I-601A, for those folks who don't know what it is, it's something that Obama decided was fair to do. And that was for people who needed, when somebody leaves the country and they've overstayed by 6 months or they've overstayed by 1 year, they're subject to bars. 6 months, you can't come back for 3 years. 1 year, you can't come back for 10. So people who can't adjust their status, and I'm going to make this very simple, who cannot adjust their status would have to go home for their interview. And by going home, even if they're going for something as salutary as, as good as their immigrant visa interview, they would be barred from coming back. And they could apply for a waiver, but that waiver took very, very long to get. And they would be waiting outside the country. Some of our clients have HIV, they're living in conditions that are just horrific, separated from their loved one, et cetera, et cetera. Obama said enough. In many circumstances, you can apply for that waiver while still in the United States, so that when you go for the interview, you've already overcome that ground of inadmissibility. That was Obama's administration. Yes, it was then formalized by regulation, as required under the Administrative Procedures Act, but, and published in the Federal Register. It went through the whole rigmarole. That rigmarole could go on again. It could be taken away. And, I think about that as well. And, although this cannot change overnight, it can change.
Right.
Scott, I
or
actually
just a little, and
oh, sorry, keep going.
I'm sorry?
Oh, I was just gonna add to Noemi's point. If we think about the provisional waivers and how many different memos have come, we've had two different. First with reason to believe, and now with the expansion for LPR spouses. So my concern is that when we got rid of reason to believe for criminal convictions, I mean, I remember back when they first started, people with DUIs were being denied, and that could quickly change.
Very quickly.
And that scares me. We might still have provisional waivers, but who's eligible to go through the process? I'm scared that there might be a memo that says, actually, we're going to go back and do it this way. So
the restrictionist administration, restrictionist agency, people at the helm of these agencies, Sessions as Attorney General,
So I hear, and I think that's right, the complexity of immigration law, the deference at the field level in immigration law, those are all things that really scare y'all. If there's a move in the administration to be more restrictive, that's embraced by people throughout the system, regardless of whether there's any change in the law or not. And Paul, did I hear you have a question?
Yeah, I just got a question from one of our people who are calling in, and so I just want to make sure that we had time to ask it, but I did not want to interrupt. So I think this is a great time, and so the question from one of the listeners is that transgender immigrants are often placed in solitary confinement, with the most common rationale being that by immigration agents being that it's for their own safety. Have you seen this practice trending in one direction over the other in recent years, and do you see this changing at all in the future?
That's a great question, and one actually I was just about to ask. It was one we had been thinking about already. Elaine, did you want to address that, or?
Right. So the answer is yes, that's something we're seeing. And unfortunately, while we have the studies have shown, I think it was the Center for American Progress that did a really good study about what it was like for LGBT folks in detention, and also further research on trans folks and the assault rates within custody in detention facilities. And one of the things that we're seeing is that, yes, they call it administrative segregation, which is, yes, solitary confinement. It's usually a punitive measure. And what we're seeing is that it's happening with the trans folks, but also with individuals who identify as lesbian or gay, or who are accused of being lesbian or gay. I have clients that came in as unaccompanied children that were placed in detention after turning 18, and both have been bullied. Both of them just were imputed. People perceived them as gay. And for the young lady who was accused of being a lesbian, when she told her deportation officer that she was being bullied, the response was to put her in administrative segregation for 3 days. She did not feel threatened. ICE's position is, for the safety purposes, is that if the person expresses a fear that they cannot be safe in the population, and then they can be placed in administrative segregation. But what we're seeing is this is being used for anything, just mere harassment. The solution is, oh, sorry, we're going to put you in solitary confinement. In terms of the transgender population, there were talks, and we brought this up on our call yesterday, of seeing what was the latest on a detention center that's being constructed in Alvarado, Texas. It was supposed to open in November, which would have a unit for a transgender population for approximately 36 beds. As far as I know, that has not happened as of yet. I don't have confirmation that folks are actually transported to that facility who have identified as transgender. But the one last point I want to make, before we even get to detention and solitary confinement, what I think the bigger push is making ICE come to terms with its own policies. They have risk classification assessments, which is basically like, think of it like a checklist when they have somebody in their custody and they're making a decision, should we detain this person? And there's a section there for folks that express a fear based on their gender identity and sexual orientation. And so the push should be, these folks shouldn't be detained to begin with.
A very good point. And in particular, when you were talking about solitary confinement, I mean, there's been a lot of research about the harmful effects of solitary confinement, particularly over a longer period of time. And to the extent that that's being done to, supposedly protect someone, it's a really misguided approach, I think.
And the harmful impact is particular on young people. So.
Right, yeah. And I would add, there's along with research on solitary confinement, there's a lot of research about detention for asylum seekers and how that impacts their trauma, exacerbates trauma, the long-term effects. And if you take an asylum seeker who's fleeing persecution because of their sexual orientation or because of their gender identity, and then they're placed in solitary confinement, that impact in itself is detrimental. And the fear is that we've seen, and these are just cases that we know of, where folks give up and they go ahead and sign their removal because they don't want to be continued to be detained.
Mm-hmm. That's the goal.
Yeah, and I think that is the goal in part. That's I guess that's part of self-deportation, huh? what is I guess thinking about detainees a little bit outside of the context of LGBT people, what happens? Like, let's say a whole family is, arrested together. They're put in detention. Where do they end up? Like, would they all end up together in a friendly facility, living as they would outside, but in a different sort of context with walls around them, like at Crystal City during World War II, if you were interned, or is there something else, or where might they be placed, or how might they be housed?
Right.
Elaine, you can address that.
Yeah. So there's no beautiful housing with rainbows and unicorns outside the window. It depends who's fleeing from the family. So if it's a family unit composed of a male father figure and a female mother and children, what'll happen is the father will be placed in a male detention facility, and the mother and her children would be placed in a family detention facility, which right now would be either in Karnes, Texas, Dilley, Texas, or in Berks, Pennsylvania. If the child is unaccompanied, under 18 and coming by themselves, they would be placed in the Office of Refugee Resettlement, which is for minors, unaccompanied. They like to call them unaccompanied alien children. I just say unaccompanied children. And then from there, they would be released into the custody of someone who would take custody of them, their custodian. So for the family detention unit, right now, there's efforts in Dilley, Texas, from the Cara Pro Bono Project. In Karnes, Texas, there is a project there as well, mostly through Raíces, which is a nonprofit that's working with these women and children. And then in Berks, there is a presence in Berks for also Pro Bono Council, and the Cara Project does have some involvement in Berks as well.
And Cara, that is, I guess, a combination of Clinic, AILA, the American Immigration Lawyers Association, and Raíces, right? It's these three organizations working together.
No, and the council, the American Immigration Council as well.
Exactly.
Mm-hmm.
Right.
And so, and they're working in particular, I guess, at Dilley, but also in some other places. Is that right?
Right. Right now, predominantly Dilley. Raíces does the bulk of the work in Karnes. And the reason that is, and I'll just take a moment to explain it, is because the government was sued over these conditions. Initially, Obama shut down family detention. It popped back up in 2014 with Artesia, which were trailers. Women were housed in like trailers in a federal law enforcement training center. The conditions were deplorable. The council also filed suit against that detention center. And the government, what they did was, when they shut down Artesia, New Mexico, the center that housed 600 women and children, they shifted them to Karnes and Dilley. And so the project morphed into trying to figure out where these women were moved to, and then the population continued to increase. And so the project is now trying to cover these three detention facilities. Berks is smaller in capacity, while Dilley houses 2,400, and I believe Karnes is 900. And so because of such a large increase, and these are all women who are fleeing from persecution with their children, and the government has processed them through an expedited removal. What that means is they detain them, and if they express a fear, they'll put them through an interview process where an official will determine whether they're credible or not. And if they're credible, they get to pursue their asylum application, or if they have a prior removal order, then they would qualify for something that's called withholding of removal, which essentially says there's a removal order, but we're not going to enforce it, and you can reside in this country, and we'll give you a work permit, but you will not be able to apply for residency or citizenship, which asylum, folks that win their asylum cases, asylees can, after having a year of asylee status, then file for their residency and then ultimately their citizenship. So it's a different context, a different route, but all these women are being funneled through, and if they have a positive, credible determination in their interview, the government, because of a lawsuit in Flores, has to go ahead and start processing them for release. They cannot have prolonged detention with their children. Unfortunately, there are cases where women have been detained with their children for months, and a bulk of those women are in Berks, Pennsylvania.
I have one question here, which I know the answer to, but some of our listeners might not, which is, do people in this situation, when there is a hearing on their asylum claim, do they have a right to counsel? Or do they have counsel provided, I guess I should say?
Right, yeah. There's a right to counsel, but there's not a right to appointed counsel. So what that means is, like in a criminal context, you would have an attorney assigned. You have a right to have an attorney at the government's expense, like what you would call like a public defender. In immigration context, there is not.
And so there's a great need there, and my understanding is that even someone who may not be an immigration expert like yourselves could actually do a lot of good in a place like Dilley, right? Y'all were both, as I recall, I think you've both volunteered and worked with families down in Dilley. Can you tell us a little bit about your experience there?
Yeah, Noemi, do you want to go first?
Oh, sure. Yeah. Well, I went once. It was in this past April. I went with a group of ALA attorneys from New York, and we spent a week there doing different tasks that were required to help these women in tension with their children to succeed in their credible fear interviews, so therefore they would be eligible for release, whether by paying bond or the ankle monitor, which is a nightmare in and of itself. But in any way, and personally, the first time I saw the women walk into the big room in Dilley with their children, some of us really almost fainted because it was just such a moving scene. Awful. They've all been assigned jeans and T-shirts of different colors, and the children were, crying, and they're uncomfortable. And the food that they're eating there is not the food that these kids have been used to for their tender years. And the women looked unhappy and who would not be. And, they warmed up to us as we talked to them, and, so they saw that we were on their side. It was probably, for many of them, the first time they ever spoke to anybody about their situation. And, we were very successful in getting them to express themselves. This was their one chance. They knew we had to impress upon them, this is your chance. This is your chance to get out of here. You have to tell your story. There's nothing to hide. For some of them, they had been raped, they didn't want to talk about it in front of their children. For them, the children had been raped. Some of their children had been killed. There was one woman that I spoke to. Her son was the product of a rape, and she had never told him. She thought that another man was the son's father. I mean, their stories are just horrific. These women they deserve to be free. They deserve to live freely in this country. They didn't want to leave their countries. They had to leave their countries. They don't want to be here, but they have no choice. There's no way that they can stay with their children in their countries. They'll all be killed. We know of the stories of how many have returned to their countries, never to be heard of again. So if it's my turn to tell the listeners that they should volunteer and go to Dilley, it is as nightmarish as it sounds. It is, as a lawyer, probably one of the most rewarding experiences I lived through.
Well, how about you, Elaine? You were there as well, right?
Right. Yeah. So I've been to Dilley twice, and then I did 6 tours in Artesia. And I would echo everything that Noemi said. These stories are horrific, but just to add a piece to that as well, I was exposed to folks who I had one mother and child where the son was gay but couldn't tell his mom and wasn't out to his mom, and was being persecuted by the MS-13, which is a predominant gang in El Salvador. And one of the things that are common for gang initiation is to assassinate someone. And young boys who are effeminate are particularly targeted. And his case was really, really heartbreaking because he had never come out to anybody. And it actually took a little while for him to come out to me. But at the same time, it was his opportunity to have this voice, but then understand that this was something that it was okay to express. And then also dealing with that with his mother was particularly difficult in working with him and his mother and that combo. And, how do you present your fear when your mother can listen to your story? As advocates, when you identify something like that, he probably wouldn't have been able to go through the system by himself. We were able to get a separate interview for him aside from his mother, so he wouldn't be having to come out to his mother while also telling his fear for the first time. And hearing him, allowing him to use his voice and tell his story, like Noemi says, it's so important. A lot of these folks don't understand that they can tell their story, but the government processes them so quickly that if they don't have an advocate, a lot of them don't get to tell their stories. So it's incredibly, incredibly important to be able to be there to help, even if you don't know anything about immigration law. The training materials from the CARA project are so extensive, and they're there to help you. And just having a presence.
And otherwise, they have no counsel, right? It's not a choice between an expert and a non-expert. It's whoever they have and no one, right?
Right. And a lot of these preparations for credible fear interviews for these women and children, we're at 90% passage rate, over 90% passage rate. Where before, when family detention first started, they were being deported when it started back up again in 2014. Before attorneys arrived, they were just a rapid action deportation mill. And so to be able to be there, help folks, guide them, listen to their stories, be there so that they understand that not, if you think about it, a lot of folks in their country don't understand that there are protections. They can never go to the police. They don't know how to talk to anybody in the government because they don't trust them. And now we're putting them through this process where they have to talk to an asylum officer. It's intimidating. And so to have an ally in that process is incredibly important.
So we actually have one last question that you all have actually answered a lot of the questions we've received, but there's one more that is related to this that I would just like to ask before we're basically out of time, but I just want to make sure I can ask this one last thing. And that is that this is actually from an attorney that works at the law school that wants to know that other than, traveling to Texas or traveling to a detention center that might be elsewhere, what opportunities exist for law students and for attorneys, for that matter, to assist on the regional level?
And I could answer that. I think that it depends on the region and what facilities might be in your region. I know in Georgia there are several detention facilities, and some of our students have recently interviewed people who were detained there, and some of the other law schools in the state of Georgia have helped out with people who were in detention. So yes, there may be some local or regional situations where you can help out depending on where you are. I know they do welcome people. The CARA officials down there are willing to help oversee a faculty member and a group of students. They've spoken at the American Immigration Lawyers Association's law professors group this past summer when I was there, and I know they would be willing to help if someone wanted to go to one of those facilities in Texas. But even if you can't do that, there may be something in your region that you can do. Go ahead.
And I would suggest that, contacting the CARA project, because I think there are things that could be done remotely, and there are things that, some women are released and, they move to certain jurisdictions where maybe a law group, without going to the detention center, can volunteer to represent in the asylum claim when the woman has her master hearing, when she has to go before the judge. I think there are lots of things that can be done. Elaine, I think they need the CARA project needs a lot of help in entering the information into into the system, that could be done remotely by people who are tech savvy and, I think with minimal instruction. So I think there's a lot that could be done.
There was a project that now has morphed into a nonprofit through the Urban Justice Center in New York for some of the students that were there from Columbia, Yale, that had essentially done when someone has a negative credible fear determination or their results are negative, their first interview with the asylum officer, filing motions to reconsider with the asylum office. A lot of those were done by law students remotely. When cases were going to their last hurrah hearing, when the women wanted to stay and fight their case, law students prepared for that individual hearing. They did a lot of the briefing, the country conditions research. So, yes, there's a lot of work that can be done remotely by law students. The volunteer coordinator for CARA is, her email address is just Erin, ERIN, at CARA, CARA, pro bono, all one word, .org. Feel free to reach out to her for remote help from law students in the project. And then to Scott's point, yes, regionally, I think Georgia has some of the worst detention centers in the country.
We do,
I'm dealing with Irwin County Detention Center right now, and it's a nightmare. So, yes, there are things you can also do regionally.
And
for the listeners, they can also do this as lawyers. So that's.
And I was just going to say, by the way, in case anyone was heartened by the Obama administration announcement earlier this year that they were going to try to go away from the use of private prison facilities for detaining immigrants. A report just came out today from the Advisory Council DHS subcommittee that has suggested that they're even before the new administration, it looks like they're no longer headed in that direction. They're more concerned about the smaller amount of people who are in county jails in immigration detention. So I think this is an issue that already exists and is likely to get worse. Certainly before it gets better, and may just get worse and worse. Just to leave us on a gloomy note, but also hopefully one that will inspire people to want to help out.
Yes, Scott. Thank you for that. And I really do hope that some of our callers are thinking about helping out. And if any of our callers have some other questions on how they can help, please feel free to email me, and I can forward along to any of our speakers that are on this call today. I also, obviously, just one last time want to thank our speakers for taking the time out of their day to help us with this call-in today, and also our co-sponsors, the HNBA and NAPABA. The National LGBT Bar Association can't continue to putting together this quality programming such as this without your continued support. So if you'd like to see more cutting-edge legal analysis, please consider becoming a member of the bar or renewing your existing membership. To learn more, please visit our website at lgbtbar.org. Thank you, and thank you again to our wonderful speakers today.